EU AI Act is a big thing for companies. What is genuinely new with that?
EU AI Act is pretty different. It's more a product safety framework, really.
And with kind of the rise of agentic AI, we're only just beginning to see some use cases in regulated industries, and those systems are taking actions rather than just producing outputs. Is the current regulatory framework ready for that?
There's going to be a learning curve for firms, that the regulators are already doing the work that they need to think about how to apply it.
Is there any kind of one thing that firms should be thinking about straight away?
The key thing to remember is that even if you've got a technology that can take actions autonomously, that you're always going to be responsible for the technology. It's making sure that you've got the policy in place, that you've got the controls in place, and that you've had that brainstorming with the different stakeholders that you need to involve in the process.
Hi, this is Matthew Cheung. I'm CEO of ipushpull. And on today's podcast, we're talking about governed data as the competitive moat in the agent era, with regulation, what's reality and what it means for the financial markets. So we're delighted to be joined by Rosie Nance, who is a senior knowledge lawyer at Norton Rose Fulbright. So hi, Rosie. Thanks for joining us.
Hello, thank you for having me.
I guess before we start, can you just talk about what you do at Norton Rose Fulbright, and kind of you're spending all your time talking about AI and the regulatory landscape around it. Just high level, can you start to talk about that?
Yes, so I am part of a team of lawyers advising on data, cyber and AI regulation. So we work across the UK and EU. And a lot of our work is in the financial services space, in frequent contact with our financial regulatory colleagues and our colleagues in the global network. We advise clients on AI questions, on specific use case questions when they've got sort of an interesting use case that they want to roll out, and also on the wider governance programs, so how to put in something that complies with the range of laws that you've got to think about. And of course, right now we're talking to a lot of clients about agentic AI and how to prepare for new use cases there as well.
So I guess then, to set the scene, with like EU AI Act is a big thing for companies. What is genuinely new with that versus an extension of existing data regulations and financial services regulations?
EU AI Act is pretty different. It's more a product safety framework, really. So I think there's a misconception that it's a bit like the GDPR or financial service regulation, that there are some principles and then some specific obligations that you need to comply with. But really, it's at its core product safety legislation. So it's made under something called the New Legislative Framework. That's what the EU refers to as a toolbox of measures for use in product legislation. So it's more like EU regulation for toy safety or lift cables or medical devices. So it's about making sure that products meet specific safety requirements. And it's not like FCA authorization, say, where you're looking at compliance on a firm basis. So product manufacturers under that framework need to meet a bunch of requirements on a product level, go through a certification process where they document how they've met those requirements, and then they declare conformity, get a third party to assess conformity, and then they can stick a CE mark on the product and place it on the market. So that's the general principle. It works a little bit differently for the AI Act and the roles in the AI Act, but that's the principle we're working with. So I suppose that's the really new thing, that you've got a very different type of framework here. And then I suppose the thing that is an extension of existing regimes is that the existing regimes are still there. So I think we often find that we're talking to clients about a new use case, and the AI Act is the thing that stands out to them because they think it might be high risk AI. That sounds really scary. But then they might find they're a deployer under the AI Act, which means that they've got some things to do, but sort of a lighter set of obligations than some of the obligations that fall on the providers. But then the existing obligations are still there as well. So as well as working through those new obligations, they've got to work through, say, GDPR. And sometimes there can be really challenging new things to work through under the existing frameworks too.
And I guess this, like you're suggesting, like the EAI Act is not in isolation. You've got GDPR that you mentioned, the Cyber Resilience Act, the Digital Services Act, the Data Act, the Data Governance Act. There's all these different things that companies need to be aware of. How have you kind of found the industry navigating that? Is it just another thing to look at, or has that changed the game at all in terms of how people are interpreting some of these regulations? And I think from that, of course, we're going to talk about agents and where that sits in that world as well, because that does then become a bit of a game changer in terms of how regulation can impact what agents can or cannot do.
You've got to think about compliance holistically, and there's definitely overlap. And some of them work together, like the Cyber Resilience Act you mentioned works with the cybersecurity obligations in the AI Act, for example. Clearly got to think about it together with the GDPR. There's obviously things that overlap. You've got to be thinking about whether you're addressing things holistically. I suppose approach is quite different for the AI Act with that sort of product safety angle. I think the key thing to start with there is to just look at which bits of it apply to you and whether you're caught under the high risk obligations, or there's some other obligations as well to think about. So transparency obligations that tend to apply to in-house chatbots. There's a general AI literacy obligation, but I think the first step is usually just to think about which bits are caught and then which role you have, because that plays a big role in how you approach compliance. And as I said, that provider role it's quite a sort of a heavy lift and something that you approach quite differently to existing obligations, whereas the deployer roles are a bit lighter.
And with that, you mentioned high risk a few times, and that's kind of defined in the EU AI Act. So what does that mean?
There are some really specific obligations. Obligations that are defined as high risk under the AI Act are use case specific. The ones that tend to bite in the financial services sector, well, there's the one that's kind of no respecter of sector, which is HR. Lots of organizations looking to use AI in the HR space. Anything to do with recruitment or performance management, that's going to be caught. So that's a high risk use case. Then otherwise the sector specific one, because it's about protecting fundamental rights as well as health and safety. There's some that bite in the consumer space, so consumer credit, and then also in the insurance space, risk assessment and pricing for life and health. So really specific use cases, but that HR one tends to catch a lot of use cases, or a lot of organizations are experimenting there. And then if you are high risk, if you're in a high risk use case, if you are the party that is developing the AI or having it developed for you, then you're the provider. And then you've got those product safety rules. So you've got a bunch of things to do around specific data governance on a product level and specific risk management and testing obligations on a product level, and making sure that's capable of human oversight, providing information, and getting together lots of technical documentation to show that you've done all of those things on a product level. So it's really different from it's not just good organizational governance, although organizational governance is the jumping off point, but you have to have shown your governance really on a product level. So that's what you have to do if you're a high-risk provider. If you are a deployer of a high-risk AI system, so that is the party that's using the tool, and that is a different set of obligations. So those aren't really, I'm not aware of other product safety legislation that has something similar, but because of AI, there's some risks that you can only manage if you're the party that can see it. So like human oversight is a good one. Actually, as a deployer, you have to put in place competent human oversight, and then you have to follow the provider's instructions. You've got some things to do around informing individuals they're using AI. So you've got specific obligations relating to your role, and there's deployer ones. They're important, but they're sort of likely to be more of an evolution of existing compliance obligations. So those are the different roles that apply if you're in a high risk use case. But yeah, they are very specific.
So looking at like an agent interacting with various workflows, tools, people, data systems, and so on. An agent, for the definition, would be a system that can autonomously plan, can invoke external tools, can execute multi-step execution chains without kind of humans being involved or perhaps a human in the loop. Some of what you just mentioned around having a log or an audit of all these interactions seems very important. It's not just compliance and regulation, but there's actually, like you mentioned about the governance piece, that's all the way down to kind of systems governance and process governance to make sure you're keeping record keeping of if an agent's doing something and how it's interacting with different services. Firms should be thinking about how they're logging all of that rather than having something going out in the wild that you can't explain why it's made a certain decision.
Yeah, exactly. So there are specific ways that you'll have to put together your technical documentation and your logging, and specific challenges around agents where things could change and where you assess conformity again and substantial modifications. So there's specific ways that you have to do it for the AI Act. But yeah, absolutely, at its core, you are going to have that logging in place. Logging is one of the requirements, and I think that's core also for a lot of other regulatory obligations that, for example, data protection, you need to be able to tell people what you're doing with data if there's any personal data involved. And for that, you're going to have to know what's going on, how your systems are interacting with each other, where it's going, and really key for financial regulatory obligations as well to have the controls in that regulators are expecting. So, and you have to have a Resilience Act if it applies to you as well. Yeah, really key for a lot of things.
Do you see in your when you're talking to kind of clients, is it often the data governance teams that are getting involved in that kind of record keeping? Like with existing teams that happen to comply with existing regulations anyway, is this just kind of widening the net of things they need to keep records for?
Yeah, I think that's a really interesting question. So, yes, data governance teams, but I think, well, particularly with the AI Act on the scene, we're seeing that it's sort of prompted more of a multi-stakeholder engagement than might have happened for other legislation. And obviously, you can never have just a compliance team in the corner doing compliance. So that's never going to work. So the doers need to be doing it. The multi-stakeholder effort needed here is a bit different. So yeah, the data governance team, also architecture, definitely the engineers that legal need to define the sort of the legal requirements, but even the process of defining what compliance looks like and how everything fits together is definitely multi-stakeholder effort. And I think even more so with agentic use cases that you need to brainstorm, figure out what the risks are and how to make it happen together.
And kind of you talk about multi-stakeholders, but also in terms of like multi-regions, you've got your Europe, UK, US have all taken slightly different approaches. Most firms in financial services operate in all of those regions. So how do you help clients make sense of all that patchwork?
It's been a lot for clients recently. They've been coming to us saying, well, we want to take a highest common denominator approach. We need to do something globally. Would the AI Act work as our highest common denominator? Can we just have that as our high watermark? And usually the answer is not really, because it's such a specific approach. So it's that specific approach to which use case is considered high risk, and then also how obligations are allocated. And there's just so many things that you could make a law about globally. So China has a really wide variety of AI laws, and the US, for example, the state AI laws are quite complicated. So it seems like California's got everything from chatbots to pricing algorithms covered. So it's not just the AI Act. And then also that you might sort of fall down on where obligations are allocated to, that I think the US, for example, sometimes obligations are allocated differently. Like if you're doing something in the HR space, it's got New York Local Law 144 has a rule on automated decision employment tools that applies to, if you're using them, you've got to do a bias audit, publish it on your website, and that's a role that would fall to the provider. So you might not have to do it if you're using them in the EU. So yeah, really different approaches. So I suppose what we find to navigate that is it's not really just AI laws that you look at as the high watermark. It's more looking at the landscape of what laws apply globally and kind of looking at what the organization does, and then figuring out a high watermark based on the range of laws. So yeah, you've got your data protection and your financial regulatory obligations, employment and discrimination, cybersecurity. So it tends to be a bit of a patchwork.
And the EU AI Act seems some of those high risk areas is kind of things involving people, kind of like employment and credit and things like that. In the world of kind of suppose like financial markets and City and Wall Street, is there any things that people and firms need to be thinking about how the EU AI Act could impact things like trading?
Actually, trading, it's more those high risk cases, more consumer focused. So it's not the area you look to for controls on algorithmic trading, for example. There's lots to be aware of sort of adjacent to that as well. So if you've got anything that you're using internally, for example, if you've got an in-house chatbot, you need to tell people that they're interacting with AI, or if you've got an external facing chatbot, you need to make sure that there's no chance that your agentic AI systems could stray into a banned use case as well, that you need to be aware of it. There's AI literacy obligations to be aware of as well.
And with kind of the rise of agentic AI, we're only just beginning to see some use cases in regulated industries of agents, which is more around productivity and things like that. And probably not too distant future, they're going to be much more widespread. And those systems are taking actions rather than just producing outputs. And that raises lots of questions around authorization, accountability. Is the current regulatory framework ready for that?
Yeah, I think that's a really interesting question. So I suppose with the current regulatory framework that you've got, I suppose data protection and financial regulation have it in common that principle-based and technology neutral. So that there's going to be a learning curve for firms, that the regulators are already doing the work that they need to think about how to apply it. Lots of work going on with the review at the FCA and the ICO, the GRCF. But ultimately, we've got this principle-based framework that can be applied. I think that it's got the flexibility to adapt. I think the regulatory framework is ready, and it's just doing the thinking on how to apply it, really.
And so I guess then that the governance piece is the systems that companies need to be setting up is kind of that action level audit trail, which they should be doing anyway around data governance, but expanding that now not just around governance of data, but governance of actions of agents and bots and so on. And that tooling needs to be at the system level and a kind of user level or an agent level to be able to record all of the actions and decisions that an agent has made. So I think we'll see some interesting kind of approaches from both the regulatory side and from the technology side. So I think just to wrap up the podcast, is there any kind of one thing that firms should be thinking about, straight away as a takeaway?
The key thing to remember is that even if you've got a technology that can take actions autonomously, that you're always going to be responsible for the technology you're choosing to use. And I think it's easy to sort of lose sight of that when you've got this complex supply chain, complex technology. So you've ultimately, bottom line, you've got the regulatory responsibility. And so taking it from there, it's making sure that you've got the policy in place, that you've got the controls in place, and that you've had that brainstorming with the different stakeholders that you need to involve in the process, and making sure that you've got the policies in place to make it happen.
Great. And is there a good place for listeners to follow you on when you're talking about AI and regulation?
Oh, yes, certainly. So we have got a blog called Inside Tech Artificial Intelligence, and very happy to share the link with that. And also, very happy to share any thoughts on LinkedIn as well.
Rosie, thank you so much.
Thank you very much.